This is the case of the state of Texas versus Caitlin Smith. A mother, originally on probation for driving intoxicated with her young children in the car, is back in court. The state is moving to revoke her probation after a series of serious violations, including testing positive for dangerous drugs like PCP and cocaine. Despite her emotional pleas about her 4 children needing her at home, the judge must decide, has she exhausted all chances, or is state jail the only option to protect the public and herself from her addiction? Watch as a life hangs in the balance.
We now call 21-38 581, the state of Texas versus Caitlin Smith. That's you.
Yes, sir.
Present with your attorney, Mr. Parker, and the state's attorney. There is a First Amended Motion to revoke probation that has been filed as of November 4th of last year. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Judge.
All right. And raise your right hand. Do you solemnly swear or affirm any statements you make today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. In summary, this First Amended Motion to revoke probation states that you, Caitlin Smith, in this cause number, was sentenced to 2 years in the state jail, probated for 5 years for the state jail felony of driving while intoxicated with a child passenger. Is all of that true?
Yes, sir.
Number 7 alleges that you committed the offense of public intoxication on or about August 23rd, 2022 in Jefferson County, Texas. Is that true or untrue?
I'm not sure.
I thought y'all were. This is 7 through 17. I thought y'all were pleading true.
Judge, she has to plead to those, and we don't know exactly which one she's going to or not going to. This is basically an unagreed hearing.
Well, then we're going to have an hearing on it.
Well, she has not entered
to choose.
She has not.
If we're not going to agree to everything,
she has not entered a plea yet, Judge, on any of those.
I mean, she's doesn't know what to do.
Well,
Maybe it's like. Do you have a plea on that at all?
No.
We're having a hearing on it. We're going to take each one at a time, and y'all get to present evidence. And that's what we do on a motion to revoke probation.
If we can maybe go through the motion and see which one she's pleading true or not true to, then.
That's what I'm saying, Judge. She still has to plead true or not true to the counts.
Which one, sir, is she going to plead to?
Can I have a minute, Judge, with her?
Did you have anything to do with this probation or showing Karen Riggs?
Yeah, I took over her case. So.
Okay, she's moved on.
Yes, sir.
Okay, where'd you go? Another probation office, maybe?
I think she went to Social Security.
Did she?
I believe so.
Definitely, there's another.
Found a motion to revoke is coming back with you unless they're mentioned.
So on Keith DeJean, and I'm sorry, on Jeremiah Butts, what are you going to do?
I have no idea, Judge. I've talked to him. You need to talk to him.
Okay.
I've discussed it with him, and he can't tell me anything since.
Okay. You were using English, weren't you?
That's the only language I know.
Well, gibberish sometimes.
That, yeah.
Okay,
Rarely.
I think you're going to hear a little gibberish out of this one.
go ahead.
All of them except for 10 and 11 she's pleading true to. Bill.
Number 7. Number 7 states in summary that you, Caitlin Smith, committed the offense of public intoxication on or about August 23rd, 2022 in Jefferson County, Texas. Is that true or untrue?
True.
8. He's failed to immediately report to the probation office your arrest. And I presume that's the arrest of number 7 you just pleaded true to, the public intoxication. Is that true? Not. You tested positive on or about August 30th, 2022. On September 7th and 8th of 2022. Or the presence of phencyclidine in your system, PCP. Is that true? It's terrible stuff. It's referred to as embalming fluid because it was used to embalm animals. That's
whatever you said.
possibly the worst thing you can ingest for your health. 10. On or about September 8th, 2022, this alleges that scientific analysis showed the presence of tetrahydrocannabinol in violation of your probation order. Is that true?
Not true.
That's marijuana.
Not true.
Okay. Were these tests at the office?
Yes.
Oh, okay. So that's number 10. What else did you say?
11.
11. Okay. 12. Number 12. It states, you failed to never become intoxicated or be under the influence of any intoxicating substance in that on or about August 23rd, 2022, in violation to be under that on or about August 20th. That isn't a complete thought. As well, does anybody have a problem? It doesn't say anything. I think it intends to say by you failed to never become intoxicated by being or by being intoxicated or under the influence of an intoxicating substance on or about August 23rd, 2022.
Judge, it says alcohol.
Yeah. Oh, I see. That refers up to number 7.
It's not in the order you normally see.
Intoxication thing that she's already pleaded true to. So it's
a little bit out of order from what you know,
right?
Yes, sir.
Everybody. So that's that you failed to provide verification of performing community service hours as required. Again, that's not descriptive really on what we're talking about. I mean, is she behind in community service? I don't know.
Yes, she had 400 assigned hours and only completed 100.
Okay, it says failed to provide verification of performing community service hours as required. It's just kind of out there in a universe without, these allegations have to be descriptive enough so that, she can narrow down the global field.
Judge, number 7, 8, and 9 are the primary allegations we intend to go on, so I'm fine with skipping anything else.
Okay, number 15. You failed to provide verification of completing the Texas DWI education program that was required. Is that correct?
Yes, sir.
And 17, you failed to successfully complete the Jefferson County Drug Intervention Program as required. Is that true?
Yes, sir.
So, are you therefore pleading true to allegations 7, 8, 9, 15, and 17 of this First Amended Motion to revoke probation voluntarily, knowingly, intelligently, and because those allegations are true?
Yes, sir.
You understand by pleading true that a knowing and voluntary plea of true is enough to grant this motion to revoke probation. Your probation can now be revoked and you can be sentenced up to the full range of this offense, which is no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Can I get a update on how much time she's served, please?
And also, Judge, here's the PSI.
Okay. Go ahead. There's no agreement, I presume.
No, Judge. And I'll let her address the court on some of these allegations that she pled true to. The drug intervention program, she states that the reason that she did not successfully complete that is because she says she called and her color was not her color, I believe, and so she didn't go in for testing. But apparently there's some misunderstanding or miscommunication about that. The community service, well, we didn't do that one. She tested positive for PCP a while back. That's been an issue that she's had. She had a sister that died, and it's been very traumatic. And even though it's not a justifiable reason to use anything or any drug, that's what she did. And
PCP,
Yes. And
because your sister died?
and people deal with things different ways. I mean, it's not I said it's not a rational decision to make, but that's somebody that's addicted and has problems. They turn to their vice, and that was her vice at that time.
But that's a lethal option.
I understand.
No, I'm talking to you too. You're the key person here. That's just a lethal option.
And she is.
Do you have family at home? Is that yes?
Yes, sir. And that's one of the other things. She's been in jail for quite a while, I believe. And she was in jail, got out, and has been in jail since she tested positive in this court.
What's the point?
A few times
You're making though that she's her family needs her.
Well, yeah. Yes. I mean, she's. I think
she's using PCP.
She's.
How's that serving their best interests?
I think the PCP was a while back, Judge, and I think she's set in jail for a certain amount of time that she knows what she's done. She realizes that her family needs her. She wants to turn her life around and live the right way. She didn't realize how it affected all her family, and she does now. And she can't justify. It can't justify it, and she knows the situation she's in. She's come clean with everything she's done. She's admitted what she's done. Not proud of it, but it is what it is. And I think she'd like to address the court, Judge.
Have you represented her throughout this case?
No, I represented her. She had another case, and the day that she got put on probation on this case, and that other case was dismissed for some reason. I don't know the reasons why. And then she had a motion revoked, and I started representing her on the motion revoked on this case.
When was that? Do you think? There's a motion and First Amended. Was it on the original motion? You think?
The only motion I have, Judge, is the First Amended on my file.
Judge, I think there was another attorney prior to the First Amended. If I remember correctly, November of last year, there was a different attorney.
Judge Stevens, I just want to say that I messed up and I made a mistake, not one time, but multiple times. I have been going to the AA and Alcoholics Anonymous. I also have 2 sponsors that have been working with me. I've been trying. I'm trying, and I do accept full responsibility. But I do have 4 kids who need me.
Yes, ma'am. They do. How old are they?
My oldest is 9, and my baby is 1.
Oh, so they needed you while you're using PCP. And then the elephant in the room here is that why are you in custody now? Because you came into court and tested positive for cocaine in January. That's not even on the list of bad things. You were shuffling in here high on cocaine. A myriad of intoxicants that you're using, but here you're sniffling and crying and throwing your children out there. How many children?
I have 4.
4.
Judge, and the underlying offense for which he had pled guilty to is the intoxicating substances were phencyclidine and cocaine, by the way, just so the court remembers.
Those are terrible. It's obvious that the fact that you have children, as it's just very nature, that's a natural reaction, a natural response that you would protect your children, but you don't do. You're more worried about yourself. What if I ask for your opinion?
Then I would say something over 12 months in state jail would be appropriate.
But from the probation office, do you feel as though y'all have exhausted all avenues of assistance for her based upon her unwillingness to cooperate with the probation office?
For everything from the previous officer, it seemed like they tried JCGI and that was unsuccessful discharge. And they recommended safety, but she was adamant that she would not go. And then that just kind of ties our hands.
Okay. Oh, so there's a problem right there. She has a chance to help herself. That's a good program, but no one forces anybody. Kind of flies in the face of, I have 4 children at home. That kind of, it would be something that would be helpful to you, but that's the way you're analyzing things, which is incorrect. But that you're a grown up, you get to make a choice. Anything else anybody wants to add?
No.
If not,
No.
you know,
The only reason I did not accept safety is because they told me that I would be gone a year in 3 months.
yeah,
To the halfway
it could be a while.
Yeah, and I just said if I was gonna do that away from my kids, I might as well come home and don't have to worry about probation where I could work and travel with my twin boy. That's the only
No,
reason.
but you're still forgetting. You just don't go to St. Pete for rest and relaxation. It's not a vacation away from home from the kids. No, it's a process of helping you on treatment for a habit that you are unable to take care of. Now, but you're a grown up. You get to make a choice in spite of the fact that it is, to me, as I look at this, in your worst interest and in your family's worst interest. But you're the grown up. You get to make the choice. Nobody's going to beg. We've got only X amount of slots, and those are needed. And people who want to help themselves are the ones who get to go, because it would be a futility if you didn't have your mind in the right place, that you wanted to cooperate with the facility. And in spite of the fact that it is a very has a high rate of success, but nobody is forced. Anything else you want to add?
I'm also a trustee. I've been working since April 29th. Wondering if you probably could bring me my time.
You have 197 days credit is what you have. The court didn't want to read into the record just a summary of why you're here in the first place. This indictment, 21-385-81, alleges that you operated a motor vehicle in a public place while intoxicated, and there were 2 passengers under 15 years of age in the vehicle, and police stopped you at night here in Beaumont for driving at a very low rate of speed that was a danger to other vehicles as well as yourself. There were 2 children in the car. They were little bitty kids. One of them was it's like 1, and the other one was 4, unrestrained, not in any kind of restraint seats, and they were in the back seat. When the police stopped you, they were talking to you. The car began to roll toward another parked vehicle. They had to reach in and put the vehicle in park, as you seemed to be unable to understand what they were saying. You admitted to using a powder while visiting a friend's house on Adams Street. Your blood was tested and it had cocaine and phencyclidine in it. So, see, the problem here is that's just not you. Obviously, your kids that you're so upset about will put in harm's way. You had a chance to go to a facility that has a high rate of success to help you, but you've refused to try that method. And so you have really no tools nor self-discipline when you leave to really deal with your issue. But you made a choice. And I think it's a poor choice, but what we've got to do is now, in the situation you're in and your poor thinking, we've got to figure out how do we take care of others who are put in harm's way, like children, other people who drive on the road. All right, if nothing further, I think I've analyzed that enough. There is sufficient evidence supporting this First Amended Motion to revoke probation to grant it by a preponderance of the evidence or greater, as allegations 7, 8, 9, 15, and 17 have been proven true by a preponderance of the evidence or greater. Your probation is revoked. You were hereby sentenced to confinement in a state jail for 15 months. You will be given credit for the time you have served. Anything else to add? If not, that is all on this case.
You know,